Sen Cornyn.
Mr. Weinstein, you were a co-founder of the former Republican National Security Officials for Biden and obviously engaged in the political process during the last election. You organized and led a public letter calling the previous president a threat to the rule of law. Certainly, you were within your rights to express your point of view and support the candidate of your choice. But can you assure Americans with whom you disagree politically that you do not view them as a threat to the rule of law, absent some criminal conduct?
Absolutely, Senator, and thank you for that question. And I want to thank Senator Rubio for letting me know that question might be coming. If you permit me, I'll spend a minute or so just giving you my position on that. That is a completely fair and appropriate thing for you to be asking about. You should ask about the political activities of people who come before you to take these positions in the national security and the law enforcement enterprises. Because the last thing, as I said earlier, the last thing we need is anybody in these positions of authority in the national security apparatus who is allowing, injecting politics into decision-making, undercuts the effectiveness and the credibility of the national security apparatus. So it's fair for you to look back at it and at political past. The thing about me is there really is not much political past up until 2020. I've been a government guy, was promoted by parties, administrations on both sides, and basically my job was to do what was best for the American people and not for a particular political party. I felt strongly about the last election, and I think an important point here is the thing that I felt most strongly about, and you alluded to that letter I organized, was the concern that there was politicization of the law enforcement enterprise at the Justice Department, and that's the centerpiece of that letter. And it was that concern that really made me feel like I should be vocal. And that's the concern that I think you have, right? That's what I'm worried about, politicization. So I've spent my life as a public servant resisting politicization. I did that with my advocacy last year, and you can be assured that if I end up in INA, that's the position and the principle I'm going to hew to. So thank you for that question, sir.
We talked a little bit about domestic terrorism and whose purview that falls within in terms of law enforcement. And I think you said the FBI would certainly take the lead, and absent some foreign nexus, you would agree with me that that would not be within the purview of organizations like the Central Intelligence Agency and other parts of the IC, correct?
Certainly, domestic-focused intelligence work would not fall within the purview of the CIA, yes.
And that would include use of the Foreign Intelligence Surveillance Act, correct?
By the CIA, yes.
Yeah. Well, the FBI...
against the domestic terrorism threat, yes.
As you know, having worked at the FBI, it's the FBI that fills out the applications for FISA warrants. And indeed, one of the concerns that I think everybody should have is about the abuse of some of those tools, like the Foreign Intelligence Surveillance Act, to surveil American citizens, particularly based on perjured testimony. When you read Inspector General Horowitz's report on crossfire hurricanes that documented the perjury of one of the FBI lawyers and the various other abuses of the process, did that cause you concern?
Yes, it certainly did.
And one of the problems we have here, you talked about 215. I support the reinstatement of Section 215 of the Foreign Intelligence Surveillance Act. But as I've told the Director of National Intelligence, every time that the skeptics about the power that is given to the intelligence community under the supervision of the Foreign Intelligence Surveillance Court and members of Congress, every example of an abuse of that power makes it harder and harder for us as a political matter to get Congress to pass or reinstate those authorities. So let me turn to the border. Obviously, when you see 2 million people, roughly plus, coming across the border during this last year, and instances of drug trafficking and seizures, people with criminal records, potentially people from other countries of special concern. For example, in the Del Rio sector, when I was there last, they said they detained people from 150 different countries coming across the Del Rio sector alone. From a national security perspective, is that a concern of yours?
Absolutely. Look, the border has, as long as I've been engaged in national security, has been an area of concern because of the possibility that wrongdoers are going to get into the country that way, and then contraband and the like also, from a law enforcement perspective. So yes, that is a concern.
And I realize this is not necessarily within your authority or your bailiwick, but I want to use the opportunity to highlight the fact that the Secretary of Homeland Security has actually signed a non-enforcement directive saying that the Border Patrol should not, and ICE should not detain or anybody who is guilty of illegal entry into the country unless they've committed other crimes. And the problem remains that that the non-enforcement posture of this administration and the Department of Homeland Security are operating as a substantial pull factor for people to leave their homes and come into the country illegally. Are you aware of some of the most recent statistics with regard to those who have come here and been released on notice to report? Are you familiar with that process? When somebody claims asylum, they're given either a notice to appear in court or a notice to report to an ICE office. Are you familiar with that?
Yes, sir, I'm generally familiar with it, yes.
And does it concern you that
Senator, I'll get you a third round, but
Pardon me?
You're at 7.5 minutes now. Can I get you back on the third round? Senator Wyden's been
I
waiting.
just have one more question. I'm happy to do a third round.
Thank you, Mr. Chairman. Just 2 quick points, Mr. Weinstein. First, I'm going to be asking you written questions with respect to the dossiers and whether they're going to be released and how they're going to be used, and I'm going to need those answers before this committee moves forward. That's number one. Number two, there's another part to this 215 debate. This, of course, is the bulk collection of the phone records on millions and millions of law-abiding people, where I am trying to square your public testimony with the written answers that you gave us to the pre-hearing questions. Let me make sure we walk through this quickly. In your public testimony about the bulk collection of all these phone records, you said, and I quote, that this part of the law was significantly more protective of civil liberties than grand jury subpoenas. You also testified that if the government wanted to collect, and this is a quote, an obviously innocent day-to-day action, I think you're going to have some questions from the FISA court judge. Now, on the basis of the written answers to the pre-hearing questions, you knew that the government was secretly using Section 215 to collect the phone records of millions of innocent Americans without any subsequent review by the FISA court. So for the committee, and I'll be asking more about this in writing as well, reconcile what you knew at the time based on your answers and your public testimony, because I'm having trouble reconciling the two, and maybe there's something else I need to have information from you on.
Thank you. I think I can help you a little bit, and I appreciate you raising this the other day and giving me a heads up about this. So let me just so everybody's on the same page. You're asking about testimony I gave in September 2009. That was after I left government.
In public.
In public testimony that was in a hearing that related to the reauthorization of certain parts of the Patriot Act, including the 215 provision. I was asked to testify as somebody who had worked in that area. I'd left the National Security Division, where I had direct responsibility for that area as of late 2007 or early 2008. But I opined about the importance of reauthorizing those three, I think it was 3 sections that were up for reauthorization at the time, including 215. And the point that I was making was actually a fairly simple point, and as you and I discussed, the premise for 215, for enacting 215 as it was enacted in the Patriot Act in 2001, was that on the criminal side, criminal investigators and prosecutors could use a grand jury subpoena when they needed to get records, any physical document or any physical thing, but really records. A prosecutor could just issue a grand jury subpoena and say, I want those Mattel records, I want those bank records, what have you. And I did that thousands of times in my career. Don't have to go to a judge. The comparable provision for getting records on the national security side under FISA was 215 that required the Justice Department attorneys to go to a judge, explain to the judge why there was information that was relevant to a terrorism investigation, and persuade that judge to authorize that order. So in my mind, it's always better to have a judge in the process, and that's more protective of civil liberties, because someone couldn't just go use 215 for an innocent purpose, as I was explaining, to find out about, his girlfriend's whatever records or something like that. So that was the point I was making, that it's more protective of civil liberties. The issue that we're talking about in terms of the fact that it had been used and authorized by, I think, a series of FISA court judges, that the 215 order could be used to get all this metadata, telephone metadata. That was actually raised earlier in the hearing that I testified in. David Criss, who was then the sitting Assistant Attorney General for National Security, made the exact same points I just made about the value of having a judge in the process and the importance of that to civil liberties. He also mentioned in his written statement, he sort of specifically singled out to the members that there was a classified collection under 215 that that some members knew about, that he was happy to brief those members about that classified collection, and that's the metadata program. And so that was already out there. That was sort of the baseline for the hearing. I was there for that. And so when I was talking about it, I was talking about how those 215 was designed vis-a-vis how grand jury subpoenas are designed. And that's still, I think, a valid argument for 215.
I will just tell you, my time is up. I continue to find it hard to reconcile what you knew. And at the time you gave this public testimony, when you talked, and I quote here, about how 215 was significantly more protective of civil liberties, you knew that the government was secretly using Section 215 to collect all these phone records on millions of innocent Americans without any subsequent review by the FISA court. And so this is not just a policy question with respect to 215. Members have differing opinions. I'm going to have to get some more information to you from you with respect to reconciling what you now have indicated you knew at the time, which does not seem to me to be consistent with what you said publicly. We'll continue this discussion, and thank you for the extra round, Mr. Chairman. And Mr. Weinstein, we're going to, on both dossiers and this 215 matter, we're going to need some additional information. And as I told you when you came in, I'll continue the discussion with you. Thank you, Mr. Chairman.
And if I may, Senator, just a couple points. One, at that point, by the way, I'd been out of the National Security Division for 2 years. So I didn't know actually what was still running or not. I knew that it had been authorized. At some point, I learned it had been authorized previously before my coming into the National Security Division. But also, you said this collection was done without review of the FISA court. My understanding is the FISA court authorized and reauthorized it a number of times. So I think there was sort of continuing review of the
Well, I'm
request.
not sure that's helpful to you, because your written answers to the pre-hearing questions indicated that you knew that the government was secretly using 215 in a way that didn't have any subsequent review by the FISA court. So we're going to have to go over this some more, and I'll continue that discussion. Thank you, Mr. Chairman.
Before I go back to Senator Cornyn, Senator Blunt, you're up next. Do you have anything else? Senator Cornyn? We're in the 7-minute round area.
Mr. Weinstein, we were talking about the border,
Yes.
and as Undersecretary for Intelligence and Analysis, what will be your role in an official capacity with regard to border enforcement and threats to the homeland coming across the border?
I believe, and I'll have still have a lot to learn about what INA's role is at the border. My understanding is it's sort of twofold. One is to provide intelligence and information to sort of the range of people or actors, enforcement agencies that are involved with law enforcement at and around the border. So making sure that state and local, territorial and tribal partners who are down around the border are getting as much intelligence as we can find about what they can expect to see crossing the border illegally, what kind of migration patterns there are, this kind of thing. So there's, on one hand, INA's job is to provide that intelligence to those agencies, as well as within among the federal agencies and within DHS. But then also to collect intelligence that might be gleaned from people who are coming across the border. So, whether it's when people who are taken into secondary and ask questions, this kind of thing, intelligence, important information that can be helpful to the intelligence community, to DHS, to our state and local partners, is developed, and we then are responsible for helping to channel that intelligence sort of into INA and then make that into actionable analytical product.
As you know, given the volume of people that have come across the border in the last year, some 2 million, that, by the way, doesn't count the so-called getaways. It's always struck me as odd that we try to estimate people we never see, the number, but we know it's more than are actually detained along the border. And among those, law enforcement's identified people with criminal records, multiple offenses, drug smuggling, sex offenders, and the like. Currently, there's no process in place to actually do biometric identification of all the people who are coming across the border. As a law enforcement professional, does it concern you that people are coming across the border for whom we have no record, plus positive or negative, and then they are released into the heartland of the country and given a notice to report or a notice to appear, and just in the last 6 months, 50,000 of them did not show up at an ICE office given their notice to report and just violating the terms of their release. Do you view that as a national security and a law enforcement vulnerability?
It's always a concern for those in national security and in the intelligence community when you have a blank space, when there is a lack of information about people here in the United States and what they might do. And so the more that we can learn about and from the people who are coming across the border, the better. So as an intelligence guy, I want to know more rather than less. And so whether that's from interviews, from making sure they go through the process, or what have you, absolutely, it's better to know more. And whether it's coming across the southern border, whether it's coming through our airports and ports, we want to know more rather than less about the people who are here in the United States.
And do you consider our lack of knowledge about those individuals a national security vulnerability?
I guess I'd say that a lack of knowledge about people coming into our country is troubling because we want to know more about these people than less. We want to have an understanding whether somebody is coming in for malign purposes, whether it's to launch a terrorist attack or what have you. So, absolutely, whether it's people coming across the border, whether it's people coming through airports, whether it's people coming in as refugees, what have you, and I know this is the approach of DHS, would want to have more rather than less.
So that would be a yes, it is a vulnerability?
Well, vulnerabilities arise from lack of intelligence and information. And the intelligence enterprise is all about, as you know, this committee and you know all too well, is all about minimizing vulnerabilities. You minimize that by having information before a threat becomes a reality. So my feeling is that we reduce our level of vulnerability the more knowledge we have.
Thank you.
Thank you, sir.
I believe Senator King has one.